Good morning. My name is Shana Horton. I serve as the rules attorney for the Texas Alcoholic Beverage Commission. Today's date is July 13th, 2021, and we are here today for a public hearing on proposed rules in Chapter 33 and Chapter 45. This will also be an open meeting under the Open Meetings Act because we expect to have a quorum of our commissioners present to observe. As you can see, I have Commissioner Mack here in person at headquarters, and other commissioners are intending to sign on and watch via Zoom. There will be no action taken today, and they're merely here to observe and see what you all have to say. So I say welcome to Commissioner Mack, and I know Chairman Lilly and Commissioner Atkins are also signed on. So would you like to?
Good morning, everyone. Thank you for being here in attendance. This is a really important item. Thank you, Shannon, for everything that you've done, and we're ready to hear from the public and move forward with this item.
The video that we're taking of this will serve as the minutes for this open meeting. And let's talk about some procedure. So as usual, we will be doing this meeting in two parts. Actually, in this case, it'll be four parts because we have two rules. So first, we'll talk about the Chapter 33 rules. We'll have an exchange that's back and forth that is off the record. And then I will open the public hearing, at which point, if you want to make formal comments, that is your opportunity to make formal comments. And what a formal comment is, that means that I will draft a written response to that comment, which will be published when the rule adoption preamble is published. So if you want to make informal comments, that's the first half. If you want to make formal comments, that's the second half. If you make an informal comment in the first half and I'm unable to answer to your satisfaction, you will need to get up again when we open the formal comment period and make those comments again. We'll do that for Chapter 33, and then we'll repeat the process for Chapter 45. As always, if you don't want to make oral comments today, you're welcome to send written comments to rules@tabc.texas.gov. The deadline for that, I believe, is August 2nd. So the sooner the better, but up until that date, we are accepting written comments at rules@tabc.texas.gov. Okay, some more rules. When you do speak, please, the first time you speak, say your name and who you represent, and then each time you speak after that, say your name once again so that we can identify you for the recording. And I think with that, we are ready to go through our presentation. We're having a brief presentation this time. It's a little bit different because our commissioners requested that we provide a little bit of additional information on our fee setting process, sort of the formula and the weights of the various components and the data sets that were used by our divisions when they were determining their regulatory effort. So we have prepared a brief presentation on that. We'll do that first, and then we'll get to the comments. Okay, are we on slides? Okay. Proposed fees development process. Again, this is intended to answer some of the more common questions we've been getting. This is not doing anything. Oh, there we go. Okay, thank you. Steps in the development process. I just want to highlight what we were looking at. The first two items come straight from the statute, Texas Alcoholic Beverage Code 5.50. So we considered relevant information, including the type of business being regulated and the level of regulatory activities associated with each certificate, permit, or license. Second, we ensured that the commission didn't overly penalize any segment of the alcoholic beverage industry and avoided imposing an undue hardship on small businesses. Again, all four of those kind of bolded items are straight out of the statute. And then our third step, obviously, is here today, is getting stakeholder input and making adjustments based on that. And we have actually already made some adjustments based on stakeholder input regarding undue hardship on certain segments of the industry. So we appreciate that feedback from you all. Okay, there's a lot of information on this slide, so we'll leave it up for a bit. And of course, if you would like a copy of this slideshow, you're welcome to request one. Each of our divisions, as we've explained in the past, each of our divisions has came up with a regulatory effort value, sort of weight for each type of permit and license. And each division chose their own data set to make those decisions based on what kind of data they keep. So you can see here what each division used to make those judgments. Law enforcement used the number of investigations, cases and protests and inspections associated. They have a great deal of data on that. Legal used the number of referrals to TABC for each license and permit type. So that was just kind of your basic day-to-day caseload. And then complexity of cases referred, there was an additional consideration of the, those really, really big cases that go to appeals and tend to take a lot more regulatory effort over a longer period of time. And so that was a way of accounting for those. For audit and investigations, they used a number of different components. So complexity of the audit, the number of inspections, number of complaints, complexity of complaint investigations. They did a really good job, of course, being auditors, of coming up with a very well-founded data set. Excise tax and marketing. They looked at whether a license or permit had all three functions of their division. So does it implicate excise tax? Does it implicate marketing practices work? Does it require product registration? Something that required all three components of that division would be have more regulatory effort. Time intensiveness, again, some things just take a lot longer than others, and those folks in that division know which tasks are more time intensive. And then whether the permittee or licensee is required to file a monthly excise tax report or submit product registration applications. So those are kind of the different functions of that division and how they decided which of these types of permits and licenses would take more or less regulatory effort. Licensing decided to use a number of resource requirements for associated investigations. So as you are probably all aware, some licenses and permits require a very basic application, and some require a great deal of legwork by licensing to investigate things like the personal history sheet, criminal history checks, who the owner of the premise is, business organizations. There's certain things that just take a lot more research. And so that's how they decided on the regulatory effort for each license and permit type. So those are the data sets that were used by each division. And if you'll recall, let's go ahead and go to the next slide. So if you'll recall, we did double the weight of law enforcement. So you can see there on the balance of considerations, the regulatory effort is the first five blocks there. And essentially that's 75% of the weight of all of these considerations. So we've got basically 12.5% for each of the other four divisions: licensing, excise tax, marketing, audit, and legal, based on their judgments and their data sets. And then law enforcement, we doubled. And the reasons for that are at the bottom of the slide. Obviously, we have to fund our law enforcement half of our agency with these license and permit fees. And they are about 50% of our employees and a vast majority of our regulatory effort. And so the human trafficking investigations have to be covered, underage compliance operations, stings, other resource intensive investigations like stings and that sort of thing, just take a lot of money and a lot of time. And so we felt that it was appropriate to give them more weight than the other four divisions, which are much smaller in size and don't take up quite the amount of regulatory resources. So that's the first five categories there. And then you'll see the last two on the right are geographic scope and extent of privileges. And this was our way of taking into consideration just the fairness amongst the different types of businesses that we regulate, We wanted to make sure that if a certain permit or license type was similar in geographic scope, in other words, statewide, maybe countywide, maybe just a single premises, or if the extent of privileges is similar, you can deal with the same number of types of alcoholic beverages, for instance, that those license and permit fees would be within the same range. And that's just a matter of not, another way of not unduly penalizing anyone, and making sure that we're just being fair across the board. So that is the essentially the formula. That's the weighted percentages that we used to set these fees. And then we just allocated it across the 37 now license and permit types that we have based on that input. Let's skip ahead. A lot of folks have asked about comparing our license and permit fees to other states. Again, we always look at things like we always look at what other states are doing. That's part of, as an agency, that's important to us. But when we looked at this and we tried to do it in this context, it was just really not possible to make a comparison, and it wasn't even apples to oranges. It was more like apples to brisket, and of course we're the brisket. But it's really impossible to compare in any way when these other states some of their alcoholic beverage agencies don't have a law enforcement function. That's about half of what we do. Some of them have licenses that are availability is limited by population. Some of them have sort of like the New York TABC system where you only have a certain number of these medallions you can give out, so only a certain number of licenses you give out. Some have state-owned package stores, as we all know. There are different categories and classes of alcohol types. Of course, they have different licenses and permits. And with all of those differences, we just really couldn't find a way to make an adequate comparison between ourselves and any other states. But we did look at what they're doing, and we are aware of the markets in other states and of the licenses and fees that they have. It doesn't lend itself to any sort of direct comparison. So that's why that's one reason that wasn't part of our consideration. Another is that we were focusing on, of course, the required considerations of the legislature. Okay, and that concludes the slideshow. So I hope that answered some of the questions that have been outstanding. Again, if you want to ask additional questions about it, you're welcome to shoot me an email, or I can send you a copy of the slideshow as well. So with that, let's see. We have one question about what is geographic scope. Geographic scope, again, is some of our permits, such as consumer delivery, are a statewide permit. You get one permit and you can operate anywhere in the state. Some of our licenses and permits are for a particular county, and some are for just one premises. For example, if you get a license for a mixed beverage for a bar, that's going to be limited to that bar. So that's kind of the geographic scope is, it was a big, medium, small. And then we wanted to make sure that people that were kind of had the same geographic scope, were in the same general vicinity as others that were similarly situated. So, okay, with that, we'll go ahead and we're going to start, of course, with Chapter 33 rules. Anything in Chapter 33, not just the new fees. 33.23 B is the new fee chart. But we can talk about anything in Chapter 33, and this is going to be the informal discussion. So if you ask questions now, I will try to answer them to the best of my ability. If I can't, I can get back to you later. And then if you want to make a formal comment for the record, we will do that in part 2 here in just a moment. So with that, just go ahead, and we've got questions popping up. Okay. Explain the RMLE fees. I don't know the answer to that.
You can do a fee schedule for local jurisdictions.
I don't know anything about that.
Can you just ask for a clarification?
Yeah. We have a question. Can you explain, Deborah Richardson, can you explain the RMMB fees and fee schedule for local jurisdictions? Can you elaborate on your question? I'm not sure I understand what you're asking about. Is this the counties? Okay. Yeah. If we're talking about the counties, Marianne Morlock is here and she's been working on that project, so she can answer that for us.
So as far as the RMMB fee, so RM was a term that we used to represent a mixed beverage that in which a food and beverage certificate was required due to the local option election. And so we're just getting rid of the moniker RM. And so on a permit, you would see either a mixed beverage or you'd see mixed beverage with FB required. So there's no change in how the fees would be handled. The proposed fees are the same for the MB as it is for the MB with FB required. Hopefully that answers that question. And then I think the other question was about local fees. And so for local fees, nothing changes for cities and counties in terms of what they can charge, because the fees that they charge are based on fees in code on August 31st, 2021. So even though we are talking about new fees right now in Rule 3323, those would be applied to all applicants and those permittees that are renewing September 1st and later. But cities and counties, for those same permits and licenses, are charging a fee based on what's in the code on August 31st. The only exception would be for a brewer's license or a brewer's self-distribution license. Those two particular licenses will not exist until September 1st. And so for those two licenses, you would apply up to 50% of the fee in rule, which has not been adopted yet. And that is because of right now there's a brewer's permit and a manufacturer's license. Those are essentially going away and to be replaced by a brewer's license. So that nuance with the local fees is the only one that has a fee in rule.
Did that answer your question, Deborah? Will local jurisdictions get an example of their fees allowable to charge? Yes. We are required by statute to post that, and we will be posting that. Okay. Question for Amy Harrison. Would you please go back to the data sets you used and use licensing as an example with more specifics of your data sets? So licensing is that last category. I'm trying to go in and find their data sets. If you can remember anything else on that.
While you're looking at I can answer another question.
Okay.
So there was another question about the mixed beverage. I think what Ms. Richardson you're asking about is the code reads something like, for a mixed beverage, you can't charge a fee for the first 3 years, a local fee. Nothing has changed in terms of how that statute reads. So business as usual in terms of how you handle a mixed beverage.
Okay, and then as far as, okay, good. Glad we answered that question. So let's answer Ms. Frost's question since it's on the same lines. Will cities and counties only be allowed to charge the fee effective on August 31st for the primary permit, not for the subordinates that are being consolidated?
That is correct. So let's see. Give me an example. So for a distiller, I think that they have private carrier permits. Is that right? I can't think of a good example off the top of my head. Temporary permits. So a mixed beverage will now have the authority to hold temporary events. They don't have to have a separate permit. So the only fee that is charged for them would be, as proposed, an original fee of $6,000 and then a renewal fee of $3,000. But no, you would not be able to tack on any others, subordinate authorities that are being rolled into it.
Okay. Did that answer your question? Kimberly Frost, yes. Okay. Let's go back to Ms. Harrison. She asked about the data sets for licensing, and I can give you, it's a very long list of different types of areas of investigation, and those with more required investigations were considered to have more regulatory efforts. So personal history sheet reviews, criminal history checks, owner of premise verifications, sublessor info verifications, lease agreement reviews, sublessor agreement reviews, certifications, city county comptroller, outstanding permit verifications, location and food and beverage inspections, at initiation, pre-licensing assessment, 60-day signage requirements, letters to schools and residents, school and church measurement info verifications, which I'm not sure if we're gonna have those anymore. Landlord clearance affidavits, shared premise info to determine and verify sales data, diagram review and approvals, sales data information verification, bonds, conduct, surety, and performance. Comptroller, Secretary of State checks verification and entity standings, extra look overall assessment, funding and finance information verifications, cash credit law verifications, and publisher's affidavit requirements. So that's just it's a non-exclusive list, but a very long list of the various different investigations and checks that licensing may have to do for a given application. And those with longer lists of investigations have greater regulatory effort. So are we to understand that all the processes used in the past will be used in the future? Ms. Harrison asked in follow-up. For example, ownership requirements will remain the same. I don't believe there's any changes in ownership requirements right now. Definitely not as a result of this rule package. There may be some of these that are not, so pre-licensing assessment, are we still doing that? It's a little bit different.
Yes, it's just not called.
Right, it's just not going to be called that. So there's nothing on that list that I just read that I'm aware of going away after but there might be. Let me double check that for you, but I think that this list is all of these things are going to continue to be required verifications in some cases. And not, let me know. Okay. Have we got? Let's go back up to Justin Engel. When will cities and counties match the TABC fee charge? Would it be for renewals after August 31st, 2022? Did you already answer that?
No,
Okay.
I didn't.
For instance, if the G permit, the winery permit goes to $3,400, would cities and counties charge $3,400 after 8/31/22?
No, it is required by the code that cities and counties can charge up to 50% of the fee as it is listed in code on August 31st, 2021. So for that to change, it would require the legislature.
Right. So that's going to be fixed as of August 31st, 2021 until there's an act of the legislature. From Justin Engel, why aren't the fees reduced after initial issuance? Determination of the permit license seems to be a single check and not done with each renewal. And I guess that's a question about how licensing counted those. We did talk about, there is one, the mixed beverage, that does go down on renewal for that reason. And because investigations are less after the first initial 2 years. However, we did talk about whether we could graduate these permit and license fees down or up. And we determined that the amount of, we'd essentially have to make such changes and do such additional work figuring out what the category should be for the newer or the bigger or smaller, when the cutoffs would be, and then verifying all of that the additional regulatory effort would kind of eat up any of the savings that we could have passed along. It just didn't work out mathematically because of the level of effort that would be required for that. And if renewals, I'll have to look in more closely into what licensing did there to see if they did anything different for renewals. But I don't think they did. I think
No.
it's just
Because it was based on the permit type,
Right.
and so it's not just about the licensing effort, as we've already talked about, it's the other divisions, and whether it's ongoing reporting for marketing practices, the product registration that's involved, obviously the law enforcement effort, because it doesn't stop after a 2-year permit. With the renewal, there's ongoing activities involved, reporting underage compliance checks, the audits that are involved. So it's ongoing from all different divisions of the agency.
Talked about, it's my recollection.
There's a question that we missed.
okay. We've got questions coming in quickly, so hold on just one moment and let us look at it.
There was one previously.
Okay, there was one higher than that.
There was one, someone asked about sake and if it was considered a malt beverage, which is really more of chapter 45, maybe. So I know I can.
Yeah, we
answer
will be
question.
getting to that.
Okay,
It's
so maybe hold that question.
yeah. Let's hold the question about sake until we get to chapter 45. Okay, where are we? We're public companies versus moms and pops. This is from Amy Harrison. We're public companies versus moms and pops considered at all for fees in any area of regulation. No.
We don't capture that information.
That's not data that we have. And that's not something that is part of the consideration of the fees that we set. Again, it's hard for us to, without some sort of data capturing and probably some direction from the legislature to decide what counts, as a big business and what counts as a smaller business. That is something though that we will continue to look at if there is a good way to do that. And of course, we also looked at each of these fees. We asked people to come in and tell us if the fee was going to really cause them financial hardship. We don't want to negatively impact the market. Of course, that's our job here is to support the market. So if there was a fee that a mom and pop said, this is going to be unmanageable for us, we either reduce it or tried to do what we can to help. But what we can't do right now, because there isn't a different category of permit for a small business, we couldn't assign it a separate fee. But again, that's something that maybe we can look at gathering that data and see about doing in the future. It's just something we couldn't do right now. Okay. Yes. Amy Harrison asked, taking just one data set, we're back on licensing data sets. For example, personal history sheet, which are not required for all permit holders. Please explain specifically the weight it was given. So if I think it's just a judgment of, if you have one type of application that requires 3 types of investigations, that's going to have, a lower regulatory effort than one that requires 10 investigations. I think it was just an overall, based on the number of things they're going to have to do and the amount of time that they spend on it, that the applications that are on the lower end are weighted lower and the ones that have more are weighted higher. And that's just based on the knowledge of that staff of how many have to be done for each type of application and how much time each of those investigations requires. And that's really as specific as I can get. Subordinate licenses. Here's a question from Don Opperman. Please clarify subordinate licenses for cities and counties. If there are subordinates at 8/31/2021, then they go away effective 9/1/2021.
Not all subordinates go away on September 1st. The subordinates that will remain are forwarding center authority, a branch distributor's license, brewer self-distribution license, brew pub license, food and beverage certificate, a late hour certificate, local distributor's permit, and water park permit.
But the rest of them will be rolled up into the primary permit. And so, yes, essentially go away.
Yes.
But you'll still have the privileges. They just won't have a separate permit. So, do you want to scoot over? I feel like you're answering lots of questions. Okay. Did that answer your question, Dawn? Let us know if it didn't. Okay. Got it. Great. Let's see. Deborah Richardson asks, local governments may collect their own fees within their jurisdiction based on license and permit fees as they exist in the code on August 31st. Correct. Pending the governor's signature, HB 3897 authorizes them, local governments, to levy a fee based on the fees set in 3323 for 2 license types to become effective September 1st, 2021. As a result, that's correct. Okay, so this is I guess a comment. So there are 2 license types that are essentially brand new. And so we couldn't go by reference, the legislature couldn't go by reference to what was in code on August 31st, 2021, because they did not exist in code on August 31st, 2021. And those 2 new ones are, remind me.
Brewer's license and brewer's self-distribution license.
Brewer's license and brewer's self-distribution license. So those will be based on the fee set in rule. But the rest will be based on the statutory fee as of August 31st. So you're right. Thank you for that clarification, Deborah Richardson. I can't do that. Okay, for Justin Engel, for in and out of state manufacturers, aren't nearly all regulatory efforts cost the same for compliance? If so, why are in-state fees exponentially higher than those out of state? One of the reasons that the in-state fees are higher is because there's we don't do investigations, on-site investigations of anyone out of state. So there is more regulatory effort involved in our on-site investigations and in fact in all investigations of our in-state manufacturers. And I think that really accounts for the difference. Okay. Two license types. Okay. Okay. She says that makes sense. That makes sense. Okay. Michelle Weaver, Lone Star Liquor Licensing. Would you like to unmute yourself and ask a question, or are you just signing in? Okay. Okay, from Amy Harrison, 25% of fee is for enforcement, with examples combating human trafficking and sales to minors. How is the fact that other agencies and locals involved in these efforts considered? That was not part of our consideration. So we considered our level of regulatory effort, period, and didn't, there was no need to then subtract from that for other agencies because we only considered our level of regulatory effort. And like I said, you know, it's fully half of our employees are in that law enforcement realm. So, you know, there's a lot greater regulatory effort there. Okay, so from Michelle Weaver, if an applicant obtains a wine-only package store, which includes the BF, does the city and county official collect for both permits?
So after September 1st, the wine-only package store will have the authority to sell malt beverages. So the only permit that is required for them is a wine-only package store. The BF will not, they will no longer have the BF. So the cities and counties could collect 50% of the wine-only package store fee as it exists in code on August 31st.
Okay. Deborah Richardson, I understood that anything that is listed as a certificate, such as a food and beverage certificate, local jurisdictions cannot charge for, but everything else they can charge. Is this true? So yes, our legal division has made the determination based on the statute that we are only cities and counties are only supposed to be charging for licenses and permits, right? Licenses and permits, but not certificates. So that is correct.
So the change that is happening is right now there are 3 different types of late hour permits or licenses. And through the sunset process in 2019, it changed to a collective late hour certificate. So going forward, cities and counties will not be able to assess a fee for a late hour certificate.
Okay. Justin Engel, can you expand on your explanation of why TABC is deeming a need for an additional 1.4 million from 694 winery permit holders when during stakeholders and previous commissioners hearing, it was stated the new fees were to be revenue neutral? When compared to out of state, does this mean TABC is commanding the nearly $2,000 more for on-site investigations? Can you provide budgeting and actual numbers to support these increases? Okay, so this is just sort of a misunderstanding of how we did this process. So we started with our essentially revenue neutral goal because that's what we believe the legislature intended us to collect. And then one of the things we had to do was obviously recalibrate everything based on the considerations that the legislature required. So regulatory effort being part of it. But we also had to go from 75 permits down to 37. Which is necessarily going to increase fees. There's just no way around that. If you have half the number of permits and you have to collect the same amount of money, that's going to increase the fees. And that's part of the reason for each and every one of these fees. And the other part of the reason, of course, is what we showed you earlier, regulatory effort balanced with the geographic scope and extent of privileges. So no, we're not saying that it costs $2,000 more for an on-site investigation with out of state and in-state. That's not, we didn't add up the numbers. Frankly, we don't have that data. That's something that if we wanted to get that data, we would have to, start a new system. So we instead just had to go kind of the other direction. And so there's no data of the type that you're requesting of how much it costs to do an investigation, and I imagine it varies quite a bit. So that's why we did it the way we did it. And asking about budgeting and actual numbers to support these increases, yeah, that's just not the method that we use, and we do not have that specific data that you're requesting. Amy Harrison asked, how were self-compliance checks used in the data sets and was their compliance rate considered? The system is still not working and people appear to be non-compliant, but they are. I am not aware of that situation. If you could please, Amy, shoot me an email and I will check with, I'll check with licensing and find out what's going on with that. That's not within my knowledge at this point in time. Why was time intensiveness used for excise tax and marketing and not for licensing? Asked Ms. Harrison. Again, each division was able to come up with their own data set based on the types of things that they track. And I would say that, licensing, the number of and resource requirements for associated investigations is just another way of saying time intensiveness. So, we thought it was best for each division to use their own components and their own language to describe how they're interpreting their regulatory effort. But I think that those two things are probably essentially the same or very similar. They're counting up time intensiveness by the number of investigations and the difficulty of those investigations, whereas excise tax and marketing had that as a separate time intensiveness category. They probably aren't that different in actuality. Okay. Did the divisions come together to ensure their data sets were not duplicative in efforts and coordinate their efforts? From Ms. Harrison. yes, we've spent lots of time together. And of course, Mary Ann and I aggregated all of the data. And we know that they were using different data sets because they were using what was available to their division. And those are separate data sets of separate information. So licensing wasn't thinking about what excise tax and marketing has to do at all. And excise tax and marketing wasn't considering licensing's work. There is no overlap. And, you know, the group came together all repeatedly over time, and Mary Ann and I and others working on the project, you know, we made sure that we weren't double counting. Additional questions? Would it be possible to take one permit type and explain the numbers with the variables? That is not something I can do right here on the camera. We don't have that ability, but let me get with you privately, Amy, and I'll see what I can do to help you understand that better. Let's see. Justin Engel, under sunset, the LK and GS permits were to be eliminated. Please justify the additional expense on the G permit on the agency post September 1st, 2021, when a total of 44 permits were held over the past 4 years. So a total of 44 permits were held over the past 4 years. Okay, so this, I think the assumption here is that that we're adding in the LK and GS permits costs in to the G. And again, that's not how we went about this process. So while those privileges may become privileges of the G permit, that doesn't translate into we are just adding those fees at all. We did not. That's not how we came up with these numbers. We had to take our revenue goal and then back out from there. No, so I think, this is a follow-up from Mr. Engel. He says this is about your bundling effort on G. Follow up your slides from stakeholders and commissioners meeting is not correct then, specifically on the G. No, I think that you might be misunderstanding what those slides are intended to show. They're intended to show that the G permit now has all of those associated privileges, but it is not intended to show that all of those privileges were added up in cost and tacked on as a dollar amount, because that's not what we did at all. And I think the reason that the dollar amounts at the bottom is to show you, like, this is the value that we're having to recoup somehow. The value of all these other fees, obviously, we can't just eliminate them and eliminate that revenue. We're having to recoup that revenue within the G permit now. And that's not to say that we just added up that number, but we are going to have to, we can't just not charge any fees for any of those privileges anymore, because then we wouldn't be making our revenue target. It's as if we took the 75 permits and just eliminated 30, whatever half of that is, and just made that, zeroed that out, we wouldn't be able to meet our target. So I think that was the purpose of those slides, and I can see how it can be a little bit confusing the way they were shown, but the intention there was not to show that we bundled and added those dollar amounts together. It was to show this is the value of these subordinate permits or these bundled permits that are not going to exist anymore, that we need to recoup within the G permit itself. We don't expect that you'll be using all of those, and we know that. That's not what that was trying to show.
Do a brief pause and see if any commissioners have any comments real quick. Now, commissioners, just want to give a opportunity for you to ask any questions or give comments. I believe Chairman Lilly has a question that he wanted to ask, but also we have Commissioner Atkins. If you have any questions, please take this time to speak your questions. Are they online?
Should be able to unmute themselves and speak.
Yeah, unmute and the floor is yours if you have any questions.
Can you hear me?
Yes.
Chairman, how are you?
Good, thank you. I just wanted to, first of all, thank the staff for their responsiveness. You know, we have tried very hard to be as transparent as an agency as possible. We recognize that no one likes taxes going up and nobody likes fees going up. While we cannot necessarily assuage every concern, we certainly heard some very strong comments in the last commission meeting. But what I hope we can do is to provide what we're doing here, which was driven not only by the staff, but also by the commission, to allow as much transparency in the process as possible. It's not a perfect world, but we want to make sure that the industry knows that their success is a primary hallmark feature of this agency. And so we went about this with a lot of careful consideration. And I hope that that is very apparent today. So I want to thank everyone in the industry for all the great questions. Keep them coming. You know, look, we've got thick skins, and we can take it. We can take a punch when we need it, and sometimes we need it. So this is a collaborative effort, and so I appreciate everybody's involvement.
Mr. Mack, this is Commissioner Atkins, just following up on Chairman Lilly's comments. I really appreciate this meeting, the transparency that you provided. It has certainly provided some clarification for me, and I hope the rest of the industry. As Chairman Lilly said, this was a daunting and difficult task, but I love the approach. The amount of work that went into this is greatly, greatly appreciated. So it's not going to be perfect, but we're making significant strides. So thank you for your time today.
I echo the same. And, you know, I think some of the questions that we received from the participants today are worthy questions, and some of which I believe I've asked in private numerous times, one of which is the aggregation of data versus large and small business owners. And I believe, and I don't know if Clark, if we need legislative authority to do this, but from a form basis, I think we probably could change some of our forms and ask some of those questions so that we could actually aggregate some of that data, because not all businesses are alike. But that's something that we can do down the line. But I think to the extent that the industry participants give us these ideas and we can execute, I do think it's something that we should talk about. But again, kudos to Shanna and your team, and Sippy, you guys have done a great job. I mean, very thorough, very, very thorough work product here. And I don't know if we have any more public comments. Do we have any more questions?
There's nothing else has come in.
No.
Oh.
Well,
The actual factual fee.
Deborah Richardson.
Deborah Richardson. Is this the local jurisdictions? Deborah Richardson asked, when will the local jurisdictions get the fees and fee schedules so they can prepare their billing systems? So it's going to be published on our website on September.
I'd say by the end of the month.
By the end of the month?
Because we're going to have a webinar or a virtual event, excuse me, targeted at local governments.
Is it TABC Talks? Or?
August 10th. I don't know what it's going to be called, but
Okay.
But stay tuned. So for August 10th, there will be a live event targeted for local governments. Excuse me. As far as what will be your fee schedule, it's the same as it is now, with the exception of the brewer's permit, manufacturer's license go away, and there will be a new brewer's license. But other than that, your fee schedule and what you're able to charge is the same as it is now. And I guess with the exception of some of the subordinates that are going away.
Okay. Ms. Harrison, with all due respect, the message here is we are the government. You need to trust us. We appreciate knowing the data sets, but please explain how the data sets were used with actual factual figures, or is that possible to provide us? That is, you know, if you want to put in an Public Information Act request, that's something we can look at. Bits and pieces of that are going to be deliberative process, so we'd have to look at which parts we can provide and which parts we can't under that act. Jack Thompson asks, what was plus or minus of last year's budget? I don't really understand that question. Could you explain a little bit more? In the meantime, Mr. Engel comments that he also filed a public information request and has received no information available. So that's something, I'm not a part of the public information team. So that is not something that I would know about, but that we can talk to. Was there a shortfall or overage in last year's budget? So the way our budget works is that we have to collect enough revenue to cover our own requirements, and that's for operations as well as for things that are not part of the regular budget. So things like pension, which obviously as an agency that has a large law enforcement component, we have a lot of that we have to fund as well. So and that's what where our budget comes from. So I'm not sure about the shortfall or overage. Everything we collect goes into general revenue. It doesn't come to us to be spent. So it's not like we collect money and then we spend out of that same account. It goes to GR, and then our budget is given to us by the legislature. So does excise tax revenue go to the TABC budget? That goes to the comptroller, right? Yeah. So excise tax revenue goes to the comptroller, is not part of TABC's budget. Okay. From Amy Harrison, I appreciate you advising to use the open records request, but that info is usually denied or is withheld or takes months for these types of requests. So therefore, those details of factual figures are not available. If that's the determination that was made under the act, then that's the determination. It's not a part of the process that I'm a part of, but I trust our public information team that they are doing what they do in accordance with the law.
Next steps of what we're doing.
Yeah, sure. Okay, so before we do the formal, we need to move on to the formal comment period. It's already 11 o'clock. So before we do that, just wanted to let you know where we're going next on this, and that is that we're going to continue to receive your comments through August 2nd at rules@tabc.texas.gov. That's the email box, and of course, receive your comments here in the formal comment period momentarily. Then at the beginning of August, early in August, we're going to have another commission meeting, open meeting, at which the commission will consider the proposed fees, and they may make changes from the dais or not. They may choose to adopt with amendments, and then these fees must go into effect by September 1st. So that is the schedule from here. We do so in other words, there is still time to make changes.
And to the extent that we get additional comments, I'd ask that you send those over to the commissioners as well, so they can kind of follow what's happened post meeting, so we could just be apprised of the categories of questions and
Absolutely.
what people are asking. So August commission meeting. And then just a clarification, and Clark, tell me if I can ask this question. I believe at our last meeting, we stated that to the extent we reduced fees, that would not jeopardize our adoption. We can reduce any fee, any increase would be problematic.
Right.
Okay. All right. So if to industry, if you have data that can support a reduction in a fee, or if you have data sets that you think are valuable to the commission to see that helps your argument as it relates to what our anticipated adoption of fees would be in August and why they should be reduced, please communicate that to staff. We want to see that information and have requested that information be distributed to the commissioners. So I do think it's very important if you have data sets that you provide them so that we can review them and have that as a part of the basis for any decisions that we make.
Yes, and I want to thank Commissioner Mack and Chairman Lilly, Commissioner Atkins, and in fact, the entire commission, because they have all been very interested in and involved in this process. And they're asking great questions. They really do care what you have to say. So please do continue commenting, and I will continue relaying information to our commissioners because they continue to ask me for the information. So I will continue to relay it, and they will know what your concerns are. That's the point of the process, and that's what we're doing here. So thank you very much for your involvement, Commissioner Mack. We appreciate you being here today too.
No, thanks for everything that you guys done. And you've carried the water. So we don't have a private session.
No, there is no closed
No
session.
closed session.
So you're welcome to head out whenever you'd like.
Okay.
I'm going to start let's take a 4-minute break just in case anyone needs to jump up and run out. And let's come back at 11:05 and we'll start the formal comment period on the Chapter 33 rules. Okay, and we're back. Thank you for your patience during the break. I will now open the formal public comment period for the Chapter 33 amendments, new rules, including the fees, as well as the repeals of Chapter 33 rules that were also noticed on July 2nd in the Texas Register. If you would like to make a formal public comment, remember that I will not be responding right now at this time. You're just going to make your comment, and then I will respond to it in writing later. You may either unmute yourself and give your public comment orally. Please begin with your name and whom you represent. Or if you would prefer to type it into the chat, I will read it aloud into the record. And as always, you're still welcome to file written comments, rules at tabc.texas.gov. So with that, is there anyone who would like to make a formal public comment on the Chapter 33 rule package at this time? I don't see any raised hands. I'll just give it one more minute for formal public comments on the Chapter 33 rule package. Amy Harrison comments, Amy Harrison with Amy Harrison Consulting, with these data set factual figures would be very helpful to understand how the TABC derived at the proposed the proposed figures. Any additional formal public comments or questions at this time? Okay, Justin Engel. And Justin, if you could please type in whom you're representing, if it is yourself. Okay, Justin Engel, representing Houston Cider Co. Comments, TABC must draw a fine line when determining permit fees. Currently, the weighted average permit fee for in-state wineries is $13.70 for all permit subordinates and secondary location permits. The proposed fee increase will close many Texas producers and will also close secondary locations that generate sales tax income for the state through tourism dollars. The increase in fees for in-state producers will be extremely revenue depleting due to losses in sales tax revenue, losses in excise tax revenue, losses in permit renewal revenue, and decreased revenues associated with closing businesses. Other formal comments or questions? Again, you can unmute yourself and speak, or you can type into the chat. Okay, seeing none, I will close this formal public hearing on the Chapter 33 rule package. The time is 11:12 a.m. It is the 13th of July, 2021. With that, we will go ahead and move on to the Chapter 45 rule package that was also proposed in the July 2nd Texas Register. And we'll do the same protocol. We'll go ahead and I think, let's see. If you'll recall, these Chapter 45 rules have been amended to consolidate beer and ale and conform to other sunset bill changes and also to add back in some advertising rules that were previously repealed effective December 31st. But we're going to consolidate and readopt them for enforceability, just a belt and suspenders approach. Are there any questions or we did have one question earlier. That's right. We had a question about whether sake is a malt beverage under the rules. And Marianne says, yes, I think it is. Sake is considered a wine in the code, but it can be complicated based on the formulation. So if there's a specific product that you want to know how it should be classified, I would recommend that you get that formulation to us and contact the agency so that we can confirm for you which category that particular product would fall under. Okay, Marcus Shorts has questions about 45-122F, and he has a series of questions. So Marcus, if you just want to unmute yourself and oh, okay. Let's see. Let me pull up that section so that
Shana, can you hear me? Okay, sorry. I do think I think it will be easier to discuss. And this relates basically to the flag, seals, coats of arms, crests, and other insignia as related to advertising. I know this was a rule in place at one time, then it went away, now it's back. I have some clients that have questions generally on this one, which I typed in. These rules relate to advertising. Is there any intention that they be applied or something along those lines to actual labels?
I'm sorry.
They would be applied to labels?
Yeah, rather than just advertising. I mean, this is just about advertising. So this rule does not apply to labels.
It could. It just depends on what we're looking at. If it looks like it's endorsed by the state.
Okay, so and I can tell you, Marcus, how I look at these. You know, if you're going to have a flag, the risk is that people would be confused and think that the state is endorsing or creating or you know, is in some way formally involved with the product. And I think that, and so when these labels like that come across my desk, the way I look at it is there really any danger here that someone's going to think, you know, Budweiser is, you know, formally endorsed by the state of Texas. So it's I guess it's case by case. But I also think that there's in normal circumstances and what we usually see, there's very little risk of that mistake being made. So that's how I'd answer that question.
I appreciate that. What I struggle on, admittedly, on this F is there's a semicolon in the second half of the rule. Absolutely, positively, I'm 100% with you. The issue is before the semicolon. I'm not, and I guess I'm asking your interpretation, but it says an advertisement shall not contain any statement, device, blah, 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 which the administrator finds relates to or is capable of being construed as, you know, the Texas flag, right? Stop. And so my question is then, how does one put the Texas flag on an advertisement?
Well, I'm sorry. Okay. That's aimed at billboards, Thomas.
Remember the billboard conversation that you had with Andrew?
No. Okay, Marcus, let me get back to you on that. I totally understand your concern. And I have a response from a lawyer perspective. But from the agency perspective, I'm not sure how we are currently either enforcing or not enforcing that. So let me get some additional detail and I will get back with you on that.
I appreciate it. And let me just throw a couple other things in here while we're on this, and this is about the flags as well. I guess this is somewhat dependent upon what you come back with. But if there's an advertisement out there now, would it be grandfathered in if it's potentially against these rules, or do they need to take it down upon, the adoption of these rules?
Okay. My understanding is that there's a current issue out there that we've been working on. This rule shouldn't impact that discussion because we're readopting it. It's only been out of we basically have been operating as though these rules have been in effect the whole time because they are at the federal level. So the adoption of these rules back into rule should not have any impact on that ongoing question. I think it's a billboard question. But again, let me talk with the marketing staff and get back with you, especially since we have some things that are under review right now.
I appreciate that. And I guess just one more comment on this. I know there was some talk, or it seems like from Thomas's end, about this is mainly aimed at billboards. I would assume at the same time, though, this would go towards signs in bars and restaurants. Is that a fair statement?
The advertisement, which includes, a lot. That the definition of advertisement is quite broad. So just reading from the rules, it would apply to any advertisement, including inside a bar. I just know that the current issue that we're working on is with the billboard. That's the only reason I mentioned that.
Maybe we can consider any suggestions he has.
Yeah, we'd be happy to consider any suggestions you have for modifying this rule language. I mean,
Take out that first half before the semicolon.
I actually already wrote that down as your request. But yes, because this is actually kind of a unique opportunity. We're readopting rules that we probably should have kept in the first place. So you get a chance to take a crack at them. So we'll look into that, and I will give you a call back as well, probably with someone from the marketing staff.
I appreciate that, and I might try to give you some language too. No promises on that. Thank you.
Always appreciate it when y'all give us your ideas and actual draft language. It's very helpful. And this is something that I actually don't know a lot about. Ms. Harrison asked, what about products that have a Go Texan logo? Obviously, that's got to be an agriculture department.
We would have that.
We would honor that as long as it's compliant with the agriculture department's statutes and rules. That's something that we would allow. And I don't think we double check that. So those are allowed. See, Bob Hunt asked for Molson Coors with respect to the flag applies to product only. What about advertising and secondary packaging and displays? The way I'm reading this flag rule, it applies to everything, including advertising, secondary packaging, and displays. It applies to advertising, which again is a very broad category in the rules. But also, again, we have an opportunity here to, if you want that, if you think that should be narrowed down, we have that opportunity at this point. Other comments and questions on chapter 45? And the repeals, of course, on this one are also part of the consideration, but the repeals are only being done to make room for other rules. And so nothing substantively is actually, no content's actually being repealed, it's just being moved. Mark, you are still unmuted. Just letting you know. Okay. All right. Are there any other informal comments or questions about the Chapter 45 rule package? If not, then we'll go ahead and we'll start the second part of the Chapter 45 public hearing. Oh, here's one from Marcus. 45126C. Okay, skip down there. So 45126C, additional mandatory statements for distilled spirits, price advertising. All distilled spirits advertised with prices by package store permittees shall state the brand name of the distilled spirits offered for sale. Marcus Schwartz asks, will a picture of the product work to display the brand name if legible? Yes, that works. Thumbs up. Okay. Yeah, in fact, we might want to change the word state to display so that it's clearer. Okay, if there are no other informal comments, if there are, feel free to unmute yourself and speak or type. Seeing none, we'll now open the formal public comment period of this public hearing on the Chapter 45 amended and new rules and the repeals. So if you have a comment, a formal public comment that you would like answered in the response to comments, I will not be answering it now. We'll be answering it in writing later. Please state your name, who you represent, and make your comment at this time. This isn't a very controversial little package, so we weren't expecting a lot of formal comment, and I am not seeing any hands raised. So going once, going twice. Okay, there are no formal comments on Chapter 45. We'll go ahead and close this public hearing. It is 11:25 on July 13th, and the public hearing on amendments to chapters 33 and 45 of the Commission's rules. This meeting is now over. Thank you so much for your participation as always. And remember that you can continue to provide written comments to rules@tabc.texas.gov.